Radio show. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
Good morning and welcome to Raising the Bar, Greater RVA's Law Talk Radio Show. This is attorney Colleen Quinn of Locke and Quinn, and today we're going to talk about common employer screw-ups. How do employers keep themselves out of hot water? Lots and lots of tricky areas if you are an employer that you need to know about. And joining me today is Kati Kitstein, also an attorney with Locke and Quinn. And Katie's going to pummel me with a lot of questions today about employment law. So it's going to be an interesting show. And if you'd like to call into the show, if you are an employer, whether it's of one employee or 50 or 100, call into the show at 804-454-1366 for your free legal advice today on employment issues. Remember that Raising the Bar Law Talk Radio is shown every Wednesday at 9 a.m. And if you miss the show, there are lots and lots of videos on the Locke and Quinn Facebook page where we have preserved all of this free legal information. Also on the Raising the Bar Law Talk website, you can find the radio shows, the link to the iTunes podcast series, and also a listing of a lot of the free and reduced cost and specialty legal services that are available in the Richmond and greater RVA community. Yep.
Great resource.
Lots of good stuff. And we're going to try to get some of the stuff from today up on the website too, because we've got just a lot of things to share that are really good resources. So let's get started.
Absolutely. So this is a really interesting topic and good for people to know, especially if they are managing or running a business. So just general advice, what are the two rules that every employer should know?
You know, we're going to cover a whole bunch of federal and state law and all this other stuff, and it can get kind of confusing. But it all comes down to just two rules. One, be fair. Two, be consistent. Those are really the two things that if an employer does, they will stay out of hot water. Now, there are some other things like, basically making sure that you register your employees properly and that sort of thing. But as a general concept, I see so many employers get into hot water when they're inconsistent in the way they're treating employees or they're just not fair in how they go about running their business.
Absolutely.
Be nice.
Yeah, and that's what so many of these really technical federal and state laws come down to is you're not being fair or you're being inconsistent in how you apply the rules, and you've gotten yourself now into a lawsuit and might end up owing some money. So getting a little bit more technical, what are some of the basics employers need to know when they're hiring new employees, just in terms of making sure they're set up properly from the beginning?
Yeah, and this is where it's all the paperwork, it kind of gets a little bit intense. And there are a lot of differences depending on how many employees an employer has, but there's something fundamental to all employees, whether you have 1 or 5 or 10, and that is that you've got to get your hiring paperwork in order. So you've got to get an EIN, an employer ID number from the IRS. You've got to prepare your I-9 and your W-4 forms, and you've got to report your new hires to the state within 20 days of hire. And there are just so many good resources too out there that can help new employers. So you've got the Virginia New Hire Reporting Center, which is at www.newhirereporting.com. Okay, makes it pretty. Just Google in Virginia New Hire.
Right.
You've also got the Virginia Employment Commission, and they've got tons of information. You've got the Virginia Workforce Connection. All of these great resources online. Other ones include the Small Business Administration, the U.S. Small Business Administration. They've got a Richmond office downtown. You can walk in and say, I'm setting up a new business. I need some help. You've got the Virginia Chamber of Commerce. You've got the Greater Richmond Small Business Development Center, the Richmond Economic Development Department, the Greater Richmond Partnership. And then you've got local county resources, including Henrico County and Chesterfield County. Both have economic development offices. So like I said, Katie, we've got to get this stuff up on the website and get it in a format that if anybody writes to us at Locke and Quinn, we can also just send out this list.
Absolutely.
Because it's there's just so much good stuff out there to get started.
And it really makes it easy. There's a lot of paperwork when you're bringing on new employees, but this really, I think, makes it easy for folks to make sure that they're getting the right stuff set up so that everyone's classified right from the beginning and registered right, and your initial paperwork is all set up correctly.
Yeah, because we're going to talk about it a little bit more in the show, but one of the things that employers do sometimes is they will 1099, meaning employees, meaning they will think they can have them be an independent contractor.
Right.
And that is where they get into a lot of hot water, because the IRS closely monitors whether you truly are an independent contractor or not.
Yeah, we're going to talk we're going to talk a little bit more about the FLSA and how people tend to screw that up quite a bit. So, all right, after all of your employees are set up with the right forms, what else needs to be in place just business wise? I think, employee handbooks are things that, most employers think about. Is that something every business needs? Is this just for big companies?
I personally think that every business should have an employee handbook. Now, one thing that is a real misconception is that a lot of folks think that an employee handbook is the law.
Right.
Okay.
A lot of people call our office thinking that.
And we get all these calls that somebody will say, well, my employer violated the employee handbook. You're like, well, that's not the law. But employee handbooks are basically a nice guide for the policies in the workplace.
Mm-hmm.
How are we going to run the office? What are the general rules of work? So basically, and you have an overview of the policies and procedures. You do have things in there that are legal, like EEOC guidance.
Right.
Basically, we're not going to discriminate in hiring, firing, the provision of benefits, that sort of thing. But typically, there also will be some stuff in there about whether they're going to do background checks, whether there are going to be any medical exams or drug testing. Is there going to be random drug testing, or is it going to be based on suspicion only? Things to kind of alert employees about what's going to happen possibly in the workplace. Payroll, record keeping, pay deductions, how bonuses are going to work, leave and attendance and benefit policies. Company property, how are you supposed to care for company property?
Right.
If you damage your uniform, if it's because the dog took a bite out of, your shirt. Okay. Well, maybe the company's going to go ahead and pay for for another shirt, On the other hand, if you intentionally took your shirt and you ripped it up, well, then the company's going to say that we're not going to replace your shirt if you've got to pay for the next one, right? Also workplace safety, accident prevention. But one thing that is really important for employers to know about an employee handbook is if somebody is terminated and they make a claim with the Virginia Employment Commission. Now, so if somebody is out of work and they need to make an unemployment claim, typically if they quit their job, you're not going to get unemployment. Okay. If it's a layoff, okay, because the company has to downsize or whatever, you typically will get unemployment. And then the tricky area is when they're terminated for a willful violation. Okay, so somebody, if the employer can show that they were clearly terminated for a willful violation, they will not get unemployment. But it's a lot easier for an employer to do that if they have an employee handbook that says these are all of our rules, okay?
Right.
Because
you knew it was a rule,
you knew it was a rule,
it.
right? And if you don't have a handbook that spells out these are all the rules, it's much harder to show that there was a clear rule in place that you had to work on time, that you had to turn your computer off at night for security reasons, that you could not be insubordinate, that there was no horseplay allowed,
right.
that you basically needed to wear your uniform and show up with your uniform, that if you're working in a cafeteria or a restaurant, that you needed to have your hair net, whatever, whatever those rules might be that are out there. Absolutely. You're able then to point to them. So
that's why your boss makes you sign the handbook,
right.
So that when you try to file for unemployment, they can say, you signed saying you read and understood all of this. You knew this was a rule and you violated it.
Yeah.
So willful violation.
The other thing I see employers do that gets them in hot water is they have this great handbook and they have the employee sign, and then they don't give the employee a copy of the handbook. I mean, employees are not going to remember everything that's in that handbook. Give them a copy to refer to. Make sure that they've got that,
Right.
or it can be an electronic copy so that it's on their computer. But you want to make sure that the employees have a copy of that handbook. I mean, you spent the money on attorneys like us to go ahead and prepare it, right?
Right.
You have us update it maybe every 2 to 3 years, ideally, and we want to make sure that that's money well spent. So give a copy to the employees. So everything else that needs to go into a handbook includes drug and alcohol policies and the consequences. If you show up bombed for work, well, that's a no-no. And, it's a kind of a no-brainer, but let's put it in the handbook. Right. We talked about the conduct rules, and also most employers will have some sort of progressive discipline policy.
Right.
And that goes back to that rule of be fair, right? Because you want to give somebody a little bit of notice ahead of time that your performance is not quite up to snuff. It's not quite up to our standards. And so we want you to know that if you continue to be tardy, that by the 5th time that you're 15 minutes late for work, that's not going to work for this particular company. Right. Now, some companies can flex their, they can have flexible schedules, but most businesses operate on certain operating hours, and you need the employees there during those business hours, right?
Right. And I mean, that goes back again to showing that a violation was willful. If you do have this progressive discipline policy that says not only was it in the handbook and it was a rule that they knew that we had, but we warned them multiple times to stop violating it. And this was the 3rd or 4th time that, they broke this rule after being, having all of these warnings and having this progressive discipline. And so that makes it much harder for the employee to then go to the VEC and say, oh, I didn't know I was breaking a rule. This wasn't a willful violation. This was just miscommunication, or I thought that, it wasn't that big a deal.
We had a flex policy.
Right.
So, yeah, absolutely. And the other thing is having a progressive discipline policy also helps when employers get discrimination claims,
right,
too, where the employee says, oh, they terminated me because of my race, or they terminated me because of my religion or my sex or my age or whatever it was. And if you have a progressive discipline policy and you're able to show, no, we gave this warning and then we gave that warning, and and the warnings were in writing and it was over a long period of time, then it becomes so much more defensible for that employer to defend that discrimination claim
and say, no, this was a performance issue, not anything else.
Right. It wasn't based on your race or your color or your sex or your age or any of those discriminatory factors, or the fact that you were pregnant, or although that is another area that's a tricky area. But when you've got that progressive discipline, and the employees need to understand that the employer always has the right to not do all those progressive discipline steps if it's something really, really bad. Okay.
Right.
Like I had the case where one of my clients, the employee embezzled. Okay. So they embezzled, several $1,000s from the employer. And then that ran into several issues, which first of all was the employee said, well, what about the progressive discipline? I was like, you stole from the company, you're fired. Okay. But then we also ran into the issue of whether the employee was due their last paycheck. Yeah. And actually they are.
Yeah.
You can't offset the paycheck. So they steal $3,000 from you. You would think, okay, well, we're not going to pay them the last paycheck.
Right.
Okay. And that becomes a really tricky area because technically you still owe them for the work performed, and the embezzlement is a criminal matter.
Right.
Okay.
You deal with separately.
Right. And so you basically say, you can say, well, you can come pick up your last paycheck, but at the same time, there's going to be a police officer here.
Yep.
Or you can also say, well, we're going to prosecute criminally, and you can have your paycheck go toward restitution if you would like, but it still has to be voluntarily on the part of the employee that's done the embezzlement. So that's, I can remember my client saying, you are, he used different language, but you are kidding me. He just stole $3,000 from us, and we still have to give him his paycheck. And I'm like, yeah, unfortunately, you still owe him for the work done, even though it was shoddy work because he was stealing from you.
He was embezzling, right?
That's right. So other things about the handbook, you want to make abundantly clear at the very front of the handbook that in Virginia, it is employment at will. Okay. That means that you are at the will of the employer and you're at your own will. So the employee can walk at any time from employment, and the employer can also say to the employee, I'm sorry, but this just isn't working out. It's an employment at will situation. and either can leave. And the handbook also needs to say at the very front, it is not a binding document. It can be changed by the employer at any time, but it does set forth just certain expectations in the workplace. I mean, that's really what it's there for, is to kind of set forth those expectations in there. And it should say at the very front, this is not a contract. Right. This is not binding. This is just merely setting out the expectations. And it should at the front also say, we've got an open door policy, because I find that employers that have an open door policy tend to have less issues. If you can go all the way up to the top brass and you know that you can voice concerns to upper management, then that's going to be a smoother workplace. We actually really encourage folks that, because a lot of times their problem is with their immediate supervisor. And if you have a reporting system where you say they have to go to the immediate supervisor, well, that's just stupid.
Gotta have another option. Yeah. That's what the problem is.
Right.
Yeah.
If it's the immediate supervisor too, that's doing the harassment or discrimination, if it's your supervisor that's coming on to you, well, that's a stupid system if you have to go to your supervisor to complain first.
Go to anyone else.
Usually, you can go to human resources, or you can go to top management, et cetera. It becomes harder if it's a small shop, though, and it's like, 5-man shop, and it's the boss that's engaging in the bad behavior.
Yeah.
So
that may be a situation where you find a new job and find a lawyer.
Right.
after you're out of there.
Yeah. So we're going to talk about that in a little bit too, about how the size of a company can make a difference and what laws apply and don't apply.
Absolutely. So, but moral of the story, handbooks, very important. They keep things fair. And like you said, they keep things consistent.
Right.
Which is really, really important for especially dealing with those unemployment claims at the end. If you can show you've been enforcing these same policies across the board and, every day, then it makes the situations easier to handle.
And on that handbook issue too, a lot of folks, they can be really confused about leave, sick leave, personal leave, vacation leave. How does it accrue? Do I use it? Do I lose it if I don't use it? Does it carry over? If I leave the employment voluntarily, do I get paid out? All of that can be addressed in the handbook, which makes it a lot clearer in terms of, when it's going to be paid, when it's not going to be paid, that sort of thing.
Absolutely. So switching gears just a little bit, are all employers required to obtain workers' compensation insurance? I know you talked about sort of having a safety section in your handbook, and that's, obviously a big part of that is workers' comp for any on-the-job injuries.
Yeah. So, Virginia OSHA has great resources too, and they'll come in, they'll do training, et cetera. But you definitely need to know about workers' compensation insurance. And you and I have seen this where employers don't have it, and that becomes an issue. And Michelle Owain and I, when we did the radio show on what is personal injury, versus workers' comp claims, we talked a little bit about the problems when employers don't have workers' comp insurance. So if you are an employer who regularly employs 3 or more full-time or part-time employees, you must purchase and maintain workers' compensation insurance in case one of your employees is injured on the job. And, a lot of people will think, oh, that's only for industrial places. We don't run forklifts. Well, an injury on the job, I mean, that can be somebody moving files and
tripping.
It could be somebody tripping over the carpet. It could be somebody that, their chair breaks. I mean, it can happen in the most mundane office environments. So you definitely want to have workers' compensation insurance if you have 3 or more full-time or part-time employees. So you want to purchase and maintain the workers' compensation policy from a company that's licensed in Virginia. You want to apply to the Virginia Workers' Compensation Commission for approval as an independent self-insurer, or become a member of a group self-insurance association licensed by the Virginia State Corporation Commission, or enter into an agreement with a professional employer organization as provided under a certain code section. And again, if you contact the Virginia Workers' Compensation Commission, they're going to spell out your options for you much more clearly so that you know exactly what those options are. They make it really easy, just call them.
Just make sure you're doing it right before somebody gets hurt, and not having to deal with it after the fact.
But if you're going from hiring that you've got 2 employees and now you're hiring the third, oh, okay, workers' comp insurance kicks in, contact the workers' comp commission and find out what your options are for getting insured.
That just protects your employees and your business too. I mean, it's a good thing to have. So.
Right.
Staying on the safety issue, and I know this is one that we had come up in a case, in the last year or so, background checks. Is it, why are those a good idea to run on anyone that you hire?
Well, some employers want to put blinders on and say, oh, well, we don't need it. What we don't know won't hurt us. Okay. Right. But, we had that horrendous case where the apartment complex hired the maintenance worker through the temp agency. And the temp agency, you've got to watch these background checks because you've got these really inexpensive, cheap ones on the internet that don't really flush out everything about an employee. And so, the temp agency ran this really cheap background check. It only went back 3 years. Well, that's not good. Okay. It just so happened that this employee had a 6 to 7 page rap sheet with armed robbery and kidnapping and possession of, illegal possession of firearms and selling drugs and just a whole slew of different things. And then the temp agency never asked him about the 5-year gap in his employment, which the answer would have been, I was in the penitentiary,
Right.
And so, and in that case, the apartment complex basically relied on the temp agency's background check, which was not a good background check at all. So you don't want to rely on these cheap internet criminal background checks. And in that case, the maintenance worker, he had this whole sordid history of felonies, really violent stuff, and ends up, letting himself into our client's apartment and, raping her, robbing her, stabbing her, wrapping her in duct tape and leaving her to die. Fortunately, she didn't. She got that little breathing hole in the duct tape. Thank God for yoga and meditation and all the other things she was doing. But that was a huge lawsuit against that apartment complex and that temp agency, both employers running businesses who failed to do a decent background check on somebody that was going to have, access to all of the tenants.
Right, before they gave them the ring of keys to everyone's apartment.
And in the state police background check, it's only $15, but it doesn't, people need to be aware, it's not 100% comprehensive. It doesn't report everything that's out there. And you want to get the DMV record. If you got you can put anybody in a vehicle.
Right. If they're driving a company car.
Or even their own car and you're sending them to the bank to make a deposit. Okay. You want to get their DMV background check. And then, of course, a credit check as well for anybody handling company funds. I mean, look in the paper at all the cases where people have embezzled.
Yeah.
So we're about to cut to the break, but call into the show at 454-1366 with your employment questions. Free legal advice today.
You've been listening to Raising the Bar, Greater Richmond's premier law talk radio show. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
With SRN News, I'm Rich Thomason in Washington. President Trump has confirmed that CIA Director Mike Pompeo recently traveled to North Korea for a meeting with the country's leader, ahead of a possible meeting between Mr. Trump and Kim Jong-un. Former First Lady Barbara Bush has died. Her death comes 2 days after it was revealed that she was in failing health and would not seek additional medical treatment. Mrs. Bush was 92 years old. International chemical weapons inspectors are in Syria, but apparently they're still being blocked from accessing the site of a suspected chemical attack on civilians. That attack occurred 11 days ago. Mental fatigue may have led to the deadly engine failure involving a Southwest Airlines plane. That's the word from the lead federal investigator looking into yesterday's incident. The Dow up 213 points. More details at srnnews.com.
Dennis Prager here. For decades now. For my whole radio career, I said I'd never endorse a pain product. Then Relief Factor came along, 100% drug-free, and most importantly, my wife started taking it for her knee, and it helped her get out of pain. This is before ever advertising the product. And now many thousands of other people are saying the same thing. It works. To see if it can work for your neck, back, hip, or knee pain, the cost is only $19.95 for the 3-week quick start. Simply go to relieffactor.com.
Shop Lowe's for deals to help you save on those outdoor projects popping up on your to-do list. For your lawn, get 50% off all Pennington One Step Complete. Pennington One Step is a grass seed mix that contains mulch, seed, and fertilizer to help you grow a dark green, drought-resistant lawn. Get yours today for 50% off. All projects have a starting point. Start with Lowe's. Offer valid through May 2nd while supplies last. Selection varies by location. See store for details. U.S. only.
Office space for rent. That's right, over 1,250 combined square feet of prime location office space to lease at the intersection of Route 10 and Harrogate Road in Chester, Virginia. The space boasts 4 very large to medium-sized offices as well as a large reception area, which perfectly suits businesses like an insurance company or a financial firm. With unbeatable road frontage along Route 10, this office space won't remain on the market for long. Call 804-717-2000 now before the space is gone.
Need a break from the sound bites and the talking heads? Do you want information you can actually use? Information that'll change your life for the better? Then listen to the Del Walmsley Radio Show. Del will show you how to retire in 2 to 5 years. Your age doesn't matter. Turn off the pundits and turn on the passive income. Tune in to the Del Walmsley Radio Show.
Tune in to the Del Walmsley Show weekdays from noon to 1 right here on WNTW 820 The Answer, Richmond's choice for conservative talk. Now, back to Raising the Bar. Call into the show with your stories and questions at 804-454-1366. 804-454-1366.
We are back. Welcome to Raising the Bar, Greater RBA's Law Talk Radio Show. Today we are talking about common employer screw-ups and how employers can stay out of hot water. And whether you have one employee or you have 100 or 500, there are a lot of ways in which you can get into trouble.
Absolutely.
So we're trying to give a good overview today about how to not get in trouble and all the different resources that are out there to give some guidance. So this is Colleen Quinn of the law firm of Locke and Quinn, and with me is attorney Kati Kitzstein, also of the law firm of Locke and Quinn. And Kati is trying to pummel me with a lot of questions, but she's pretty savvy on a lot of these issues herself. Right. So before the break, we were talking about employers doing background checks and the trouble they can get into when they don't do background checks. And you know, it's amazing to me when you look in the paper how many times you see issues of embezzlement and where a credit check has not been done on somebody that's going to be handling money. We even had a law firm here in town where one of the lawyers actually was convicted of embezzlement. So, you know, it can be any employee. And if they're not good at handling money, if they've got issues with their credit, et cetera, then that's a bad sign.
Right. Well, and as we know, as personal injury lawyers, we have these, causes of action for things like negligent hiring, negligent retention, and kind of starting to emerge negligent supervision in some cases, especially where there's this physical harm, like in the case you described before the break. And so these employers who think that they can just say, oh, well, I didn't know, that can be a negligence action if you should have known,
right,
and you didn't take the reasonable steps to educate yourself on who you're hiring and who you're giving keys to or giving a car to or giving a lot of money to.
Exactly. And, you know, the great thing about us practicing both personal injury and employment law is that we can look at all those issues and dig a little deeper. If somebody is in a car accident and they're working on your business's behalf and, you know, they are running an errand for the business, but they've also been drinking on the job. And let's say they have a DUI in their background and you failed to run the DMV check. Or they've had a series of car accidents and you failed to run the DMV check, yet you then employed them in a position where they were going to be out on the road driving.
Mm-hmm.
So we're going to be looking at that from the personal injury side and saying, well, you negligently hired that person.
Right.
Or if you knew that they had those other traffic infractions while they were in your employment, well, now you basically have a negligent retention claim against them, or negligent supervision because you put them back out on the road again. So always looking for whether the employer did the right thing. Did they do the background check? And so as an employer, you want to make sure you insure yourself against liability.
Absolutely. So as we mentioned throughout the program, there are a lot of laws that govern the area of employment, some federal, some state, lots of regulations. But obviously not every business, especially small businesses, are going to have an in-house counsel lawyer on staff to advise them of all of these. So what are just some of the general basic things that all employers should understand about the law?
Yeah. So one is they should listen to the show today, right?
Yes.
Yeah. Put that video or that podcast, preserve it somewhere so you can go back and listen to it. Two, we're going to get much of this advice up in some written form up on the Raising the Bar Law Talk Radio website, so it's there. But there, again, are a lot of good, reliable resources out there. You just have to know which ones are reliable. One is for federal law, you can visit the First Step Employment Law Advisor, and that's at the Department of Labor. So it's dol.gov.elaws/elaws/first step. So again, we'll put that up on the website. But if you just Google First Step Employment Law Advisor, that'll pull that up.
And the Department of Labor generally has really great, concise fact sheets, guidelines. Just on really every employment law, issue for things for both employees and employers to know. And they break it down in a pretty understandable way. So that's just a great resource.
Yeah.
Generally is the DOL website.
Yeah, with lots of FAQs and everything, including, so the Department of Labor also has really good stuff on the Fair Labor Standards Act,
yes,
which especially under compliance assistance, because the Fair Labor Standards Act applies to all employers that are in the stream of commerce. And, if you don't pay them the minimum wage,
right,
or you mischaracterize them, and that's where we see a lot of mistakes happen, is when they're mischaracterized and they're deemed to be salaried when they technically don't fall into a salary category, but they should be paid an hourly wage, and then they're subject to overtime. And so that's where you see these class action overtime claims too.
Well, a lot of employers confuse salaried with exempt.
Right.
And that is not the case. Just because you pay someone a salary does not necessarily mean that they fall into an exemption from overtime. And this can be a really expensive mistake to make, because if you're classifying all of your employees wrong, or a whole chunk of your employees wrong, then you are going to find yourself hit with not just one employee suing you, but all of your employees suing you. And the FLSA is a pretty employee-friendly law. A lot of these, like Title VII and stuff, can tend to be a little more employer-friendly.
Right.
But the FLSA, the Fair Labor Standards Act, is very employee-friendly. It has a provision for automatic attorney's fees. I mean, it makes
There's
penalties.
Yeah.
Yeah. And so this is not a mistake that employers want to make. And it can be an expensive thing to pay back if your employees catch on that they should be getting overtime, and you haven't classified them correctly, or you've been maybe trying to pay them comp time, and do this,
right. And a lot of employers, they think you can do comp time,
right,
as opposed to overtime, but then they don't understand how that works, and
they're not doing it correctly.
They're not doing it right. Yeah, which is in it has to be within the same pay period. So it's really tricky.
Absolutely.
Most employers don't realize that that's a no-no for the most part. It's really tricky to try to do comp time. If you pay just overtime, then that's cleaner. It keeps you out of hot water.
So much cheaper to do it right on the front end than to have to deal with all of the extra costs of realizing after a lawsuit that you were not paying people correctly, and now you've got to not only pay them back, but you're looking at attorney's fees and penalties, exactly like.
And there are a lot of lawyers out there too that are looking for these cases.
Yep.
So really good stuff on the Department of Labor website on the Fair Labor Standards Act, and it's great free legal guidance.
Absolutely.
So if you can't afford a lawyer, go on that website. So we do have a question from Asher about overtime.
Yeah, you had mentioned that there are there's circumstances where you're salaried and you get overtime. I didn't know that existed. What situations would that apply to?
Well, a lot of it. So determining whether or not you're entitled to overtime is not necessarily a question of whether you're salaried or whether you're hourly. If to not get overtime, you have to fall into one of several enumerated exemptions under the FLSA. And so a lot of people, even that get a salary, don't necessarily fall into one of those exemptions. And so they still are entitled to overtime. And it's a little bit trickier to figure out what exactly that should be. But just because you're paying someone a salary doesn't necessarily mean that you might not still owe them overtime if they're working over 40 hours a week.
Right. So there are certain types of categories, such as professionals,
right.
That will be exempt. There are certain higher paid worker, which is the white collar exemption category. And so there are certain areas like where engineers and scientists and professors and stuff like that will fall into these certain exemptions. But if you don't fall into an exempt category, also certain management exemptions, you know, if you manage 2 or more employees, and there's a lot of other factors that go into that too. I don't want to oversimplify it, but if you don't fall into an exempt category, then you are not exempt. And even if you're paid a salary, you're still entitled to overtime. So the way that works is that, and I see this in a lot of retail establishments where employers will try to say, oh, they're a sales employee, they're an outside sales, they fall under that exemption, but they're actually inside the business. Okay, so that doesn't fall within. So you've got to look and see specifically, do they fall within an exemption? Do they not fall within an exemption? The mere fact that you're paying them salary doesn't mean that they're exempt.
Right.
And if they're not exempt, then you've got to look at the salary. And if they're working overtime, you need to break the salary down into an hourly rate and then pay them the overtime. So
they've earned it.
Does that answer your question, Asher?
I think I have a lot more research to do. But it sounds like it sounds like it's very dependent upon what you do.
Yes.
And there's also a lot of nuances within that.
Absolutely.
Okay.
But it is very dependent on what your actual job duties are. And for example, lawyers, there's case law that lawyers always fall into that professional exemption, and doctors,
outside sales employees.
But paralegals almost never fall into that. So, these lawyers aren't getting paid overtime, but they should be paying their paralegals overtime because there's case law on why paralegals don't fall into that professional exemption. They are non-exempt.
Right.
Okay.
And we pay our paralegals a salary, but then that
Still
gets
gotta track their hours.
We got to track their hours, and if they work overtime, then that salary gets broken down into an hourly rate, and then after that, if they work more than 40 hours, then now they're getting time and a half.
That's very interesting because that means employers should not only be tracking the time of their hourly employees, but also their salaried employees, which is not something that's normally thought about.
They should be tracking the time of their non-exempt, salaried employees. And just, really, I think what you said, educate yourself on, what makes someone exempt or non-exempt. Make sure you know and make sure you're classifying your employees correctly so that you can track and make sure you're paying them correctly.
And again, the Department of Labor has really good guidance on what's exempt and what's not exempt.
Absolutely. So FLSA, definitely a big law that employers want to educate themselves on. Any other?
The one thing that I see a lot is a lot of these employers that mischaracterize their employees as independent contractors and try to do a 1099 instead of a W-2. And the IRS is really tight on the enumerated control factors, which again, if you just Google independent contractor or you Google the IRS control factor test, it goes through and if the employee, if you're providing them with their tools, if they're coming into an office setting, if you're requiring them to work certain hours, that is not an independent contractor. So there's this whole test for the level of control that the employer has over the employee versus the level of control that the independent contractor has over their own work. And a true independent contractor does everything, generally off the premises, provides all of their own equipment, basically works on their own accord. And so that's another area where employers get into hot water. Also, of course, COBRA notices. We see a lot of mistakes there where employers aren't sending out the COBRA notice. An employee leaves employment and they're not notified of their right to stay on the health insurance. We see employers getting hot water with OSHA,
Right.
Where they're not following safety standards. And again, all you have to do is contact Virginia OSHA, and they'll come in and they'll basically do training and kind of educate, et cetera. And then what becomes really tricky, as you know, Katie, is that there are all these different federal laws that may or may not apply depending on the number of employees that you have, et cetera. So the Equal Pay Act means you have to pay all people equally that are in the same job position. And that applies to all employers in the stream of commerce. So the Title VII of the Civil Rights Act applies if you have 15 or more employees. But then the Virginia Human Rights Act captures the employers that have 5 to 14 employees. So it captures that smaller number. And what's really crazy is that if you have less than 5 employees, then you're not titled to any sort of discrimination act.
Right.
Yeah, which is a lot of, when we get calls from folks that'll say my employer's discriminating against me and they only have 4 employees, we're like, well, unfortunately, that's not protected. It's not fair.
Right.
But it's not protected. The Age Discrimination Employment Act applies to 20 or more employees. The Americans with Disabilities Act applies to 15 or more employees. The Virginia Equal Pay Act applies to all employers that are not under the FLSA. So if they're not in the stream of commerce, then the Virginia Equal Pay Act, if they're not under the Equal Pay Act in the stream of commerce, then it'll fall under the Virginia Equal Pay Act. And then, of course, the Virginians with Disabilities Act, that applies to all employers. The Americans with Disabilities Act captures 15 or more. Virginia with Disabilities Act kind of fills in that gap of the under 15, so that gets captured there. So, and it makes a difference too in the number of employees you have based on the level of damages. So, like under Title VII, there are different damage caps depending on the number of employees that you've got.
And so Title VII is the law that says you can't discriminate on the basis of sex, race, national origin, religion, the laundry list of things that you always hear.
All the protected factors.
Yeah, the protected classes says you can't discriminate, harass, retaliate. That's Title VII. It kind of covers all of the Be Fair rule that you mentioned at the beginning of the show.
The Be Fair rule, regardless of your national origin, your religion, your sex, your race, your religion, your age falls out of Title VII, but it falls under the Age Discrimination Employment Act.
Yeah.
And so, basically you don't want to discriminate. And then under also marital status, and then under sex, that also has the subset of the pregnancy discrimination provisions of Title VII. So you've got to watch out if you discriminate against somebody that's pregnant. And then also under sex, now we have evolving law that we talked about when we did the LGBT show, radio show. We've got an evolving law that protects gender expression and sexual orientation as well. So when you look at the face of Title VII, there's also some kind of expansion on some of those areas as well. So employers, again, if you're fair to all your employees, regardless of where they come from in their walk of life or, their characteristics, then you're going to stay out of that hot water.
Absolutely.
Yep.
But like you were saying, the amount of employees you have can really affect how these laws are going to hit you, especially when it comes to damages under Title VII, because there's different damage caps, and that is based on how big your business is.
Right.
So you can basically get hit with a higher possible penalty if you're a bigger business under Title VII, and you've violated Title VII.
Yeah. But it's still crazy because there's still that gap in Virginia of if an employer has less than 5 employees. It's crazy because we've had cases where on the employee side where the employee says, well, I'm being sexually harassed and discriminated against, by my male employer. And we're like, well, how many employees do you have? Does he have? Well, it's less than 5. Well, there's no protection other than looking for possible tort actions.
Right.
I mean, was there an assault and battery involved? Are there other areas that we can possibly look for some sort of a tort action, or was there a breach of contract, or was there anything else that we can possibly, rely upon in that regard?
Absolutely, absolutely. And I know business size can also make a difference. I used to do some disability, discrimination law, and under the ADA, you have to make reasonable accommodations if you're subject to the ADA for any of your, employees who can otherwise do the job with the accommodation for their disability. But what constitutes a reasonable accommodation can be affected by the size of the business. If you're really small, and the accommodation is hire an extra person to, help out with something, that may or may not be reasonable depending on the size of the business and, what it's going to cost. So that can really come into play.
So by way of example, if you've got an employee, they've got multiple sclerosis, okay, or muscular dystrophy, and you're a retail shop with 10 employees, and you're banking on, or let's make it 20 or more employees, but you're a retail shop, and so you're banking on the employees being there to assist customers, okay? If that employee with multiple sclerosis or muscular dystrophy says, well, I really need to work from home, because I need to be laying down in a prone position most of the day, that's not going to be something that employer can reasonably accommodate. But on the other hand, if you're an employer, with, let's, say more than 20 employees, and it's a computer business, or it's a business where somebody's basically just having to sit at the computer all day. Well, there's no reason really why the employer can't work from home, and you can't accommodate them in that situation.
Absolutely.
So it really can be dependent on both size and nature of the business in terms of, but you've got to look at both of those factors to see, is it a reasonable accommodation or not?
Absolutely.
Yep.
Absolutely. So what about insurance? What do employers need to know about insurance?
Well, to protect both your personal and your corporate assets, well, first of all, if you're setting up a company, you want to go ahead and set yourself up as a limited liability company, or a PC, or you've got to talk to a corporate lawyer and get yourself set up so that you insulate yourself from personal liability. Because if you just hang out your shingle and you're doing business as it's Colleen Quinn doing business as, Colleen Quinn, and I don't incorporate, or I don't set myself up as a particular corporation or limited liability corporation, et cetera. Well, now I'm just hanging out there in terms of my liability. I can be sued personally. So by setting yourself up as a particular corporate entity, now you have insulated your personal assets from liability. So I see a lot of folks that just are kind of deciding, I'm going to, sell crafts, or I'm going to, whatever it is that they're going to do, but then they don't insulate themselves from liability by setting themselves up officially as some sort of a corporate entity. And then you want to get general liability insurance on the business and the premises. And if there are any vehicles used in the business, of course you want to have automobile insurance, again, to protect yourself within the business. So, and it's really important that you set yourself up properly, because then there's this whole body of law, which you and I know, which is piercing the corporate veil.
Right.
Because if you fail to insure your business properly and set yourself up,
then even if you think you're insulated from personal liability, but you haven't gotten the insurance and, kept the money separate and followed all the rules
and followed corporate formalities, then a good attorney can pierce the corporate veil and basically then access your personal assets. So setting yourself up properly from the very beginning is, again, very important.
Very important. So what about just general rules? We've been talking a lot about sort of things to do on the front end, the setup phase of, getting your employees started. What about, once they've been there a while and you've got an up and running business, what are just some good tips for managing your employees once they're working for you?
So you want to set out specific job duties and expectations, because, that's just good communication. And it's, okay, this is what I'm expecting of you. This is what your job's going to involve. You also want to review employees, especially new employees after the initial 3 months. You want to make sure you're giving them feedback. You also want to basically sit down with your employees and do an annual review. Even if it's not a full written review with a grading system, which is recommended. However, some shops are more informal, but at least sit down with your employees and give them feedback in terms of how they're doing, what could they do better. And I actually, as you know, Katie, I have you audit me too. What can I do better, as the supervisor, in terms of how can I be a better supervisor as well. So that goes back to that kind of open door policy of free communication. We're all working to make our business a better business.
Yeah.
So you want to have that annual review process or even a 6-month review process. Also, if you've got talented, motivated, and happy employees, that's going to drive your business success. You know,
Absolutely.
that's the Southwest Airlines policy, which is, to put the employees rather than the customers first, and then the customers will follow.
Mm-hmm.
And so you want to make sure you know what's going on in your company. So, with all my employer clients, I actually have them do an annual audit and kind of annual checkup with their employees. In particular, we have all the employees sign a statement that they are not aware of any discrimination, harassment, or retaliation going on in the workplace. Mm-hmm. And of course, then if somebody claims that they've got an issue with one of those, with being harassed or being discriminated against, you pull out the annual statement and say, well, you're mandated to report this. Why didn't you report it? And why did you say there wasn't anything going on? Right. So you do want to know what's going on in your company. And you, again, going back to that open door policy. So we want to make sure that that our employees feel open to come talk to you about things that are going on. There's not going to be any reprisal or retaliation.
Right. And this is kind of an extension of the handbook. Essentially, you're kind of carrying over that same, make sure everyone knows what the policies are, make sure you're being consistent with them. A lot of this is just kind of keeping that going.
Right. And you want to have kind of like you want to have meetings periodically where you kind of request feedback, from employees. What can you do better? I mean, employees have a lot of really good ideas about sometimes how the business can be better.
Yep.
So we're getting close to the end of the show, but you're going to ask me the next question.
Yes, I am. We have just a couple more little things that employers should make sure to know about. Paycheck deductions.
Yeah, another big screw up area. Yeah, there's a lot of misconceptions about paycheck deductions. So if the uniform, cell phone, tools, etc., are for the benefit of the employer, then generally it is not legal to require the employees to pay for it. Mm-hmm. Okay? Especially like if the uniform has your company logo on it. Okay? You have to give that to your employees. And so in any deductions other than the state and federal mandated deductions, like taxes, Social Security, Medicare, they've got to be approved in writing by the employee. So, going back to the employee that embezzled, you can't deduct that stolen money from their paycheck, okay, unless they agree. Mm-hmm. So you want to have, we have a client that's a beer distributor, okay, and employees get penalized if they let the beer go stale, okay, in the retail premises where it's being sold. Well, you can't deduct that from their paycheck. Now, they can either opt to take a day in the street suspension, or then they can opt otherwise in a voluntary signed document that I don't want to take a day on the street. Instead, I'll take a $50 penalty from my paycheck or whatever it might be. So that is another area in which employers can get themselves in hot water, is making illegal deductions from paychecks or requiring employees to pay for items that are required for the job when that really needs to be the employer paying for that.
Absolutely. So I know we're getting really close to time, but just very quickly, anything employers should know about accrued benefits?
Yeah, so a lot of employers don't realize sometimes that they are allowing their employees to accrue vacation or sick leave that they need to pay them for. Right. Yep. Great show today. Join us next week where we talk about how a single dad built his family through foster care, private adoption, and surrogacy. Mm-hmm. Be a fun show.
Yep.
Where is the best news and talk? AM 820, WNTW Chester is the answer.
News this hour from townhall.com. I'm Rich Thomason. At the New York Stock Exchange, a moment of silence this morning in honor of the late Barbara Bush. The former First Lady died last evening at the age of 92, and tributes are coming in from all parts of the world. Back in June of 1999, Mrs. Bush said that the launch of her son's presidential campaign made her so proud.
I'm crazy about him, and I loved watching him on TV yesterday, and he's talking about all the things that I think America